Hello again and welcome to our next module. In this module we're going to start talking about the U.S. Supreme Court, and I always like to start this discussion off with kind of the duality of the court. I remember when I was an undergraduate poli-sci major and we would talk about these things, the Supreme Court, you have the kind of the theoretical supposed to be, then you have the kind of the reality angle of how things really work. And so there's a duality there. So let's kind of walk through this as we use this as an intro to the Supreme Court. First of all, are the Supreme Court justices politicians, right? Kind of the supposed to be, the first thing we think about, no, they aren't. They aren't elected. They aren't up for re-election. Just kind of there once they are appointed. Now the reality is they are appointed by politicians through a very political process. So even though we don't call them Republicans or Democrats, we do call them conservative and liberal. Rose being the name, right? But the thing is even though they aren't traditional politicians, which is true, they still are within. They still have to go through a political process to get to the court. All right. Next, we think about the political system and their place in that context. Kind of the supposed to be, the theoretical, is they are outside the mainstream political system. All right, and that is somewhat true. However, the reality is, even though when we watch the evening news, we hear about Congress and the president and Congress, we don't hear a lot about the Supreme Court. Is that even though they are not in the core middle of the day-to-day discussion, they still are within the core political process insofar as any ruling that they have, they don't execute. It's up to the executive branch to execute their rulings. And similarly, the legislative branch actually has to adhere to those rulings, right? They have to follow them. And in both cases, we do have examples in our history where neither the executive nor the legislative branches actually followed what the Supreme Court said. All right. Public opinion. When we think about public opinion, we think about the Supreme Court as being insulated. They can pretty much rule as their conscience allows. They can just interpret law, kind of let the mop flop, so to speak. However, the reality, public opinion does and can affect rulings, right? Now, the one example I think of is Brown versus Board. Most people have heard of Brown versus Board and know the general particulars. But when you look at Brown versus Board and study it, it was very interesting. You have Brown versus Board 1 and Brown versus Board 2, and kind of give you just a high-level review of that. In Brown versus Board 1, they basically said, nope, separate but equal, not constitutional, but come back later. And a lot of scholars, and I'm kind of of this camp as well, that they really just kind of floated out there. Remember, this is early 50s. They floated the general concept out there and then came back later, letting public opinion absorb the initial ruling to be more prescriptive later. All right. Moving on. Ideology. We think of the Supreme Court that's supposed to be objective, right? Even when the Supreme Court nominee is in front of the Senate, they always ask, well, how would you rule on a certain aspect of law? I would apply the rule of law, blah, blah, blah. Well, the thing is, most of these justices, all these justices have some sort of paper trail in terms of what they ruled on and when they sat on other federal courts and things like that. So the reality is the justices definitely have ideologies, right? And even then, it takes on average 5 years for a case to enter into district court before it might make the Supreme Court. You have a lot of scholars who track these cases as soon as they hit district court, and they'll say, okay, if this case hit the court today, Roberts would vote this way, Ginsburg would vote that way, things like that, right? Passive versus activist, all right? The supposed to be is that they are a passive element in the political process. We did talk, if we haven't already, we will in future modules, how the judicial branch has to wait for a case. They can't just go grab an issue. It has to come to them. So we do think of them as a passive element to the political process. However, in this case, we're talking about forming policy. In this respect, we do tend to think of the Supreme Court kind of deferring to the other branches to affect policy. However, the reality, the Supreme Court can have agendas. Now, let me take a couple minutes and tell you a little story about some. This does hit some of these touch points we've gotten here. And really, let's start with this last point first: passive versus activist. Well, when we got to the 88-89 session of the Supreme Court, it was one of those things that it was the first time in decades that you had a conservative majority. Up until that time, since the FDR administration, you had a liberal majority on the court. And so what happened? Now, the Supreme Court can pick and choose cases. All of a sudden, they picked 5 cases immediately as soon as they had this slim conservative majority that basically, in effect, undid a lot of affirmative action that had been put in place over the previous 25 years. So there was definitely an activist role there. And I can tell you, when I first started studying political science, we were kind of led to believe that usually didn't happen, right? But it did. Now, to kind of get back to a couple points from the prior slide, what happened after that? Well, the Congress passed initially the Civil Rights Act of 1990 to overturn those rulings. All right, I'll get to that here in a second, because a couple of you listening to this might have already picked up on something I just said. Well, anyway, Bush vetoed it, but then we move on to 1991, and Congress passed it again, and Clarence Thomas was up for confirmation of the Supreme Court. There was a backroom deal where Bush said, "I'll sign this into law if you confirm Clarence Thomas," and that did happen. What's happened since then? But remember how I told you the executive branch executes the rulings and the legislative branch complies with the rulings? And maybe that happens, sometimes that doesn't. Well, in this case, Congress passed a law to override a Supreme Court ruling. From a previous module, that doesn't happen. It takes an amendment to do so. Well, in this case, what did happen? The executive branches since Bush have pretty much not applied the standards from those cases from the 88-89 session. And matter of fact, I have taught human resource management before, and even in the textbooks will state that the Civil Rights Act of 1991 overturned the Supreme Court ruling. I'll tell you right now, it did not overturn anything. It's just there's no Supreme Court police to make us comply with what they say. And so that's just where a real world example of the supposed to be's and the realities come into play. All right, Supreme Court sometimes does have an agenda, and even with an agenda, that doesn't necessarily mean that the other branches or even public opinion will comply with it. All right, so with that, that's the end of this module, and we will pick it up with the next one shortly.